Information Commissioner's Office, Robert speaking. Can I help you?
Yes, hello. Is that Mr. Steele?
It is, yeah.
Yes, hello. It's Mr. Hussain here.
Hello,
I'm just calling back as per our pre-booked appointment.
Yeah.
Just wanted to know that have you had an opportunity to go through the case file?
I have, yeah. I have.
Have you had an opportunity to go through our telephone conversation?
I must admit I've had to skim through that, but there is notes on the phone call that Alison made.
Yes. I understand. It's a very lengthy conversation, so I understand if you've skipped through it.
I didn't realise it was going to be 48 minutes when I started reviewing it, but I skipped forward and I got the gist of the conversation and what exactly happened.
Okay.
Should I start and just explain?
Yes, sure. Go ahead.
Okay. So I've effectively carried out a review of the case today, looking at all the evidence and bearing in mind the phone call and the decision that was made and the reasons Alison quoted over the phone in that conversation. The result of the review is that my view is that the decision is right, but the exemptions, as you pointed out in the telephone call, were wrong.
Okay. Just before we continue further, one of the points I've got on the things that I wanted to discuss with you today was that I was informed following that conversation in writing, I think it was from yourself, that it would be a 30-day review period.
Yeah.
And this is one of the reasons that I've delayed contacting yourself, because I did subsequently I did attempt to ring yourselves back and try to arrange a telephone appointment. That, as you know, didn't go ahead. And then subsequently I thought, well, I've got other things to do. I'm just going to wait until the 30-day review period. Now, my understanding was that it would not be yourself that would be reviewing it. I did not, and one of the things that concerned me regarding your email was that Alison had stated to you that I was like basically railroading her to do a review over the telephone. That is clearly not the case. As the recordings will show that I was told that I wanted to get it reviewed by somebody. My understanding is that it can't be reviewed by the person that's actually made the decision. And from following on from your email, I presumed it would be somebody else. Now today in this call, you're telling me that it's not somebody else, it's yourself.
Yeah, but that's exactly the same thing. It's just not the person who's made the decision.
Yes.
It would either be a reviewing officer in my team or it would be myself.
Okay.
I don't often do them, but with this particular one, I wanted to look at this case.
Okay.
Because of the phone call. Okay.
Okay. So sorry to interrupt there again. I'm just gonna have to interject again and state that. Well, okay. If you've explained to me that often it would be somebody else within your team, and because you're a manager, you wanted to take charge of this and review it yourself. Can I then ask, why have you failed to review it within 30 days?
Well, I was just going to point out, I do acknowledge that it has taken over 30 days, and I apologise for that. We accept that, and we hold our hands up to that. It hasn't happened in 30 days, and I do apologise.
Okay, all right. I understand that. So let's just move on from this, because obviously there's no point being sort of crying over spilt milk. You've accepted that it should have taken 30 days. It's exceeded that. The second point on my agenda, just before you go forward, is that Alison had stated that I had asked for the review over the telephone.
Right. As I say, I think there's been some misunderstanding there. You're clearly saying you weren't asking for the review to take place over the phone.
At no point in the recorded conversation have I pushed this forward, but it seems that when you reply to me in the email that you sent me, you give a very different impression that I was trying to push forward something that, in essence, what you're saying to me, I think, do you have the email in front of you on the 8th of July?
I don't have that in front of me, but I do admit that obviously listening to the telephone call and also, to be honest, with the Alison's version of the phone call, it doesn't indicate to me that you were requesting the review to take place there and then over the phone. I do admit that. Okay,
that's fair enough, because obviously what's happened subsequently, I believe, is Alison, your colleague, has given you a different set of a version of events that did not occur. And obviously, one of the first things I've done is when I've received your email on the 8th of July, I've responded saying, well, wait on a minute, this was not even an issue. This is not an issue that we were discussing, or this was not a concern on my part. I was not unpleased with Alison's not reviewing it over the telephone.
Okay. I concede to that.
Okay, right. Okay. Okay, we can just move on from this then.
Okay. So what I'm saying here now is that I know you've put in a subject access request that hasn't been responded to yet because I believe they've gone back to you for further information. Is that correct? And you've responded again.
Okay, so this is another point on my one of my points that I wanted to discuss with you today. The very first point is, as you know, in the telephone conversation, I have asked for further information from your colleague Alison. She has stated to me that she can't provide that information, and I need to make a subject access request. And therefore, then we've had a quite lengthy conversation, and I said, okay, well, it's my policy to have. If you're going to tell me, in essence, direct me to make a subject access request, I will make a subject access request. I'm very versed with making subject access requests. And it's my policy to request everything from the organization. And then so the first point that I wanted to discuss with yourself is that I felt kind of aggrieved that on the one hand, Alison has told me, Miss Fletcher has told me to make a subject access request. When I've said, okay, I'll proceed as your instructions to make a subject access request, she's then stated that, it should be piecemeal. And I said, well, no, I have a right to make it, general or for everything. And therefore, we've had this debate about, how she wanted me to just make a subject access request on this case. And I've had to clarify her and clarify and correct her on several occasions that, look, that is an option open to me, but that is not the subject access request I'm making now. I am within my rights to make it over the telephone, and this is what I'm making. I'm making a subject access request for everything. So there's been this conflict where rather than taking my instructions or rather saying, okay, well, fair enough, I'll proceed as you're requesting, there was an influence on her part stating that I should only there was giving me this, but why, and you can do it this way, you don't have to do it that way. I said, look, I understand my rights, and what I'm explaining to you is that I want to make a subject access request for everything. And so therefore that's a point of grievance on my part, is that if you're railroading me to make a subject access request, I'm going to make that request but I'm going to make it on my terms because I know my rights, rather than on what you want me to do. So that's the first point. The second point is that once that she had acknowledged that a subject access request was going to be made, she then states to me later on in the conversation that, well, I'll have to gain permission from the local authority if we can disclose that information, because the purpose, the initiation of the subject access request was as a result of me asking, well, what has the local authority stated to you? And she said, well, I can't tell you that, make a subject access request. So I said, okay. Then we went through this rigmarole of going backwards and forwards, and then once she's accepted that a subject access request is going to be made on my terms, then she said that you may not even get the information because I need to gain permission from the other party. But then I'm thinking, well, why did you tell me to make a subject access request then?
Okay, I think, again, there's been a slight misunderstanding there. If I can explain what the process is, Mr. Hussain.
Yeah, sure.
It's basically we have an information access team that deal very specifically with any SARs that come into the ICO. Okay, now they will make decisions on what information is sent to you, and in some circumstances, they may have to contact the organisation to ask if certain information can be released, say like a reply from that organisation. That's not always the case, but that can be the case. Might be some information in there that is not suitable for you to see for various reasons, but I'm just saying what the situation can be. I'm not saying that's in your case.
Yep.
That's why we have a dedicated team to do that.
Okay, all right. Well, I mean, that could have been explained to me by the dedicated team. It seems, obviously what my overall arching grievance is with regards to that call handling, and particularly with regards to the complaint that was very forthright and lodging against Alison. She came across as incompetent. And she came across as somebody who does not know what she's talking about. And obviously that is a point of issue with myself. Because obviously the first point is that, she's told me to do one thing, I've followed through on it, and then she's saying, but I just have to make you aware that I have to gain their permission. And I said, okay, well, it was not her role to say that. That could have been explained to me by somebody who knows better, such as yourself, that's not always going to be the case. But can you understand that whereas one person has told me, we can't give you this information because data protection, make a subject access request. Then I said, through a lengthy process, gone through that, and then she's telling me, well, you might still not get the information.
Yeah, I understand that. And when I write up the review, Mr. Hussain, I will cover these points.
Okay.
In that review,
okay.
Service complaint.
Okay, and then just moving forward, outside of what my grievance with Alison at the telephone call, then subsequently, as you know, I've had it confirmed through the telephone call that the disclosure will take place, and she said that, obviously you recognise, much like yourself, it's going to take 30 days. Now, what subsequently happened is that, and this is a point of, I'm not sure if I have lodged this as a separate complaint with somebody else, but the phone got cut off. I'm not sure about this, but what's ultimately happened is that my understanding is that once a subject access request has been made, it's incumbent upon the organization, just like yourself and everybody else, to validate that complaint, SAR request, if it's valid. And one of the ways it's valid is to make sure that I have the rights and there's no issues with that. Now, that normally should take within the next couple of days or a week, or a maximum, I would expect 2 weeks. What's happened in this particular circumstances is that after my conversation with Miss Fletcher and her agreeing that a subject access request has been accepted, if, for example, you had contacted me back within the maximum 2 weeks for further information, that would have been acceptable. What you actually done is that 3 weeks later, or the end of the month, end of July, you've contacted me back and said we want some more information, and that's reasonable. But what is not reasonable is that for now what you've in essence done is reset the timescale until I reply to you. So I'm just concerned, and this is the purpose of my complaint, that as the regulator, you've in essence now facilitated a technique or a mechanism where if I make a subject access request to an organization and they have 30 days, and as you're aware, the legislation has changed from 40 days to 30 days. They can, in essence, wait until a couple of days beforehand and state that, oh, by the way, you didn't give us more information. We want some more information so we can reset the time to the new until you provide us with that information. And so therefore, and then after that, so now in essence, rather than 30 days, you've got in essence just shy of nearly 60 days. And at the end of the 60, just shy of the 60 days, the legislation permits them to make a further 2-month extension. So I'm just aggrieved, this is outside of the call with Ms. Fletcher, at the handling of the SAR request to date. Because as you're aware, the subject access request was made on the 8th of July. I was not contacted until the 30th of July for further information.
Okay.
I don't think that's acceptable.
Yeah, Mr. Hussain, did you say that you've lodged a separate complaint about this?
Because the person that, I'm not sure if you have the case file in front of you, but the person that's dealing with this subject access request is actually on leave until the 18th.
As I say, it's a completely different department.
Yep.
They have to be independent from us.
Yeah, that's fair enough. That's fair enough. Independent. But the lady that's lodged it, I've tried ringing her back to lodge the complaint with her directly. She's on holiday. So I have lodged it with somebody else. Obviously, I rang up the CQC and said, look, this is the situation. But after I had proceeded to lodge the call got terminated.
Right.
So I'm not sure if that, because I've gone through the process, I didn't have the call finalized to say, yes, that complaint is now lodged.
Right. Who did you speak to? Was it on just the general helpline?
That's correct, yes. Because obviously I said I wanted to speak to the person that was dealing with the SAR request, because I couldn't get in touch with her. So can I speak?
What date was that, Mr. Hussain? When was that?
I think that would have been towards the start of the month.
So early August.
Yeah, that's all. Because obviously at the end of July, I've received that email stating that we want more information and we're looking to reset the date. So in early August, I've tried to contact the SAR agent. She's told, the voice message says she's on holiday. So therefore I've got in touch with somebody else. And just like I'm explaining to yourself, I've gone through the lengthy task of explaining that, look, I don't think this is acceptable. And while the conversation was drawing to a close, the call got terminated.
Yeah. Can I just check? You said that the call was terminated. Do you know why the call was terminated? Was that an accident or?
I presume it was an accident. I'm not sure why it was terminated.
It wasn't a call that was a bit heated or anything like that?
No. Obviously, Mr. Steele, you can see my mannerisms in the way I'm speaking to yourself. It can be perceived to some people that I'm being confrontational. It's just my mannerisms. It's not the case.
I just wanted to check because obviously we do have terminated calls and we do log when a call is terminated for that reason.
No, I don't believe it was. No. It was not an anonymous. There was nothing confrontational about the call. Obviously, it was not about the person. It was about the issue at hand.
Yeah, okay. I can perhaps look to see if there's any recording of that with information access to see if that's reached them. What was the name of the person that you were trying to get through to on information access?
I'm sorry, I don't have that information in front of me.
Do you want to email it to me?
I mean, while we're talking, I can probably get it towards you by the end of the call, because I'm on my emails.
Okay.
So we can just return to this. But obviously, with regards to the main issue in regards to my call with Alison was regarding the subject access request. There was some, obviously, I've explained to you the issues I've had with Alison, and then subsequently, I've had some issues with regarding gaining that subject disclosure, which has not taken place as yet. And it concerns me that, in essence, what you have done as the regulators is provide a mechanism where you've extended your deadline time period by putting the onus back upon myself, by asking for more information.
Right, okay. But as I say, you will have lodged that in the complaint about that service of information access.
Well, like I said, I hope I have. I'm not sure if I have. If it's been I'm not sure if that's if it's been accepted by them, because obviously, like as I explained, the call got terminated, and I am waiting to hear back from the lady who's coming back on leave. I think on the 18th.
Okay. That's Tuesday next week, isn't it?
Yeah.
Okay.
So that's the subject access issue that I have. SAR request that was an issue for myself, and I've just mentioned to yourself that obviously the way that Alison has handled the call, it seems highly like she was not fully clued up with what she was talking about. Because the second thing is, as the call will illustrate, is that when she's told me regarding your privacy notice.
Yes, I listened to that situation, and all I can probably offer an explanation to that is that it is quite rare that we take these, and it possibly might have been Alison's first request, and it does say in our instructions that we must go through the privacy process, and I think some people sometimes underestimate how long that takes.
Okay, but can you?
And I think it caught her by surprise, and I acknowledge again, and I will cover this in the service part of the case review.
Yeah. Okay. All right. I mean, like I said, I'm not gonna. I didn't make a big issue with it because she admitted that she'd made a mistake.
And then she emailed it to you afterwards, didn't she?
I'm not sure if she did. I'm not 100% sure if she did.
All seem to indicate, I think.
Pardon? I think she did. Yes. I'm not sure.
Yeah.
All right. I can't verify that, but yeah, obviously the issue I had was not the privacy notice. Is that she's given me an option, and then I've taken up the option. Only to be negated, and that was the area that I was not, obviously pleased with. But she, like I said, she made a mistake, and I was not going to hold her up to it. But the second aspect, the other aspect, is the exemption that she's put forward. Now, I if you look further on in the conversation, what obviously I said that she's given me this legislation. I think it was Schedule 3, Part 3, Section, I think 11. I'm not really sure.
Schedule 3, Part 3, Section 11, yeah.
Yeah, that's right. So that's the exemptions that she's used.
Yeah, sorry, go on.
So that's the exemption that she's used. So I've got that from her. And then while we've been having the conversation, I've been looking this up. And then I have then gone back to her in the conversation, and I said, well, wait a minute, this is not relevant to what we're talking about. And then she said, no, I've made a mistake, and it's Section 16.
Yeah.
And then I said, well, okay, well, the Section 16 deals with education. And then she said, no, it's back to Section 11.
Okay, yes, I understand that. And from reviewing the case today, my opinion on this is that obviously the exemption was wrong, but they didn't need to rely on exemption, because what they have considered is that the lasting power of attorney, they're saying isn't a valid one because they haven't completed the process. So they're saying looking at the email trail of the emails between yourself and the council when you made the complaint, I can see where they've asked you and told you what that process is and what needed to happen around.
Okay, we'll get onto that exemption later on, but you can understand my point here is that not what the general gist of the exemption is. My point is that once I've rang yourself up, you've given me an exemption.
I know.
All right, and then once I've pulled you up on that exemption, you're giving me no, that's a mistake, and then we go back into it. So now today, for the first time, so before this call today, before you started reviewing it, my understanding was that was the exemption that they used. All right, now you're telling me that's the wrong exemption. Okay, But that is a separate point. The point I'm raising is that the grievance is that you've given me an exemption when I've read up on the exemption, because the impression was given that, oh, he's probably not going to read up on it, because who reads up about legislations and these are there's an exemption, or you expected me to take your word for it, when I haven't taken your word for it. When I've gone away and read the legislation, it seems that that's nonsensical. When I've pulled yourselves back up on it, Alison, Miss Fletcher, on it, and I said, well, wait a minute, this is not relevant. She's then attempted to say, oh no, it's something else. And then I said, which else? Then I looked at the something else, and she goes, oh no, it's actually the first thing. So it seems, can you understand how, like...
I understand, Mr. Hussain, yes, I do.
Okay, all right.
This will also be covered in the service complaint side of the review.
Okay, all right, okay. So it's the way that the call was handled. So now that, if it's just a one-off, Mr. Steele, as I explained earlier in the conversation, if it's just a mistake, she's admitted to it, I can move on. But when it's like a persistency of a level of incompetency, and then I think one of the remarks that she makes is that you're very confused.
Okay, maybe that's a bit I haven't heard on the call because I've not listened to all of it, but I did hear the bit where you are, obviously you've look at the legislation and you talked about international transfers. So
yeah, that's correct. Yes, so you can see that in its own, if it's one, we all, look, Mr. Steele, we're all human. We make mistakes. I'm the first to put my hand up. I make loads of mistakes myself, but there's a difference between making mistakes and then being incompetent and then looking to deflect that incompetency on somebody else, and that's where I draw the line. If you can't do something, or you not have the receive the training, that's acceptable. Put your hand up, like you and I have been open and frank about these things. So that's fair enough. But when you start then saying it's your fault, that's when I take obviously I become slightly aggrieved at that. Because that's the impression that's being given. At one point in the conversation, she does mention that, oh, you're confused. I'm not confused. And that's, that it doesn't help because you're giving me wrong information. You're applying the wrong exemptions. You give me an exemption now. So that's the situation here. I hope you've taken on that on board and we can move on from this.
I have, Mr. Hussain, yes.
Okay. So
I will address all these matters when writing up the complete case review.
Okay. Now, the next thing is that you're telling me now today that is not the correct exemption that they used.
Well,
now,
what I'm saying is, if any organisation are saying to us that they are not accepting the validity of the lasting power of attorney, then we can't make them change their opinion.
Okay, Mr. Steele,
by an exemption.
I am asking you, as the regulator, that this is a subject access request. As you know from this, that this was made in November. And just like yourselves and just like everybody else, you can validate that. There's a period of validation. That validation period, like in this case, I've raised with you a grievance. I made a subject access request. That validation period did not take place within 2 weeks. It took place at the 30th of July, where you said to me that, oh, we need more information. Now, similarly, the fact that the local authority received the request in November, they had a period to validate it. All right. Now, there is a process to validate documents, especially the lasting power of attorneys, because what you do is, if you go to because that is being administered by a third body. That third party is called the Office of the Public Guardian. Now, as you can appreciate, that's their role. And so they themselves, as a department of the Department of Justice, they're an agency of the Department of Justice, so they're remitted to administer lasting power of attorneys. Now, often, more than often, if somebody's going to be presenting you with a lasting power of attorney, you need to get it validated. So they themselves provide a validation process. So that's a very simple thing. You can either fill in the online form, providing the details to validate this. Because as you know, Mr. Steele, that it's a paper document. It can be easily forged. So they themselves provide a mechanism to do that. Now, in this particular circumstances, I can explain to you that I actually made a subject, soon as it got registered, I made a subject access request with both West Yorkshire Police and in addition to the actual people themselves, the Office of the Public Guardian. So I made a subject access request to the very organisation that is validating or creating the lasting power of attorney. Now, within the month period, made it in November, within the December period, the outside third-party agency that regulates the lasting power of attorneys has complied with the subject access request and completed it within that period in December. Following on from this, the West Yorkshire Police, whom I have also utilised the lasting power of attorney for, have had it validated. So I've then gone back to them and said, has there been when did you validate the lasting power of attorney? And they told us that within the start of December, we wrote to the Office of the Public Guardian and had it validated. Now, if the local authority had received this, and as you know, the local authority is a council, an arm of the government. Now, they had an opportunity, a window of opportunity to validate the lasting power of attorney. They did not do that. They accepted that it's valid. After accepting it's valid, they've then, at the end of the month period, asked for an extension. Now, at that point, they could have said this is invalid. But they've chosen, if for example, Mr. Steele, they had not chosen to ask for the 2-month extension, that would have been fair enough. Their argument would have held water because they would have invalidated the lasting power of attorney from day one. What they have done is accepted the lasting power of attorney, then applied the exemption of a 2-month extension. So that's now the 3 months later, back in February. And then at the end of February, they've said the fact that we don't believe it's valid and therefore provide us with further information. Now, I'm not sure, Mr. Steele, if you are fully versed with the Mental Capacity Act, but I am. And the very first principle of that act states that everyone is to be assumed to have capacity. And in this particular circumstances, the onus or evidential ability is upon them to tell me or my brother that he lacks mental capacity to have it invalidated. Now, as it stands today, we're now in August. The subject access request was made in November. As it stands today, anybody can have that validated. It's a valid lasting power of attorney. So the points I'm trying to bring to your attention, now that you've informed me that there is no exemption, but this is what they've advised you or what they've said to you, what they've advised you and said to you is incorrect. And I have reprimanded them on this, and I have said the onus is not upon myself, the onus is upon yourself. And what concerns me, particularly, Mr. Steele, is that this is now a legal instrument recognized in law that they are looking to invalidate. And they can do that if they want. You don't have to accept anything. I believe that they are wrong to do so. What concerns me is that you're taking what they're saying on their face value alone, that this is potentially an invalid document, but it's not been proven to you otherwise. But irrespective of that, as the regulator, all you can do is that a valid subject access request was made, an extension was sought, and no exemption has been presented to you.
No, but if an organisation is not trusting the LPA, then they have a right to refuse.
They don't have a right. If they're Mr. Steele, I'm sorry to obviously pull you up on this. You can present me or I can present you with a driving violation, right? You've been speeding. Here's a camera. Here's a photograph of you, and you can turn around and say no, I don't accept it. How is that a valid defence? Similarly, sorry to interrupt. Have you, as the independent party, validated the lasting power of attorney?
Sorry, have we validated it?
Yeah.
Well, we didn't have any reason not to validate it, but the council obviously have, and that's their decision. And this is where I'm saying, Mr. Hussain, is that decision that they've made, that's outside of a data protection issue.
That's not outside. So my brother, because they're refusing to accept a legal instrument, then my brother does not have a right to the his data. Is that what you're telling me?
No, what I'm telling you is that if they've made that decision, they're fully entitled to make that decision.
They're not entitled to make that decision. Well, please tell me how you believe they're entitled to make that decision. I've presented them with a legal instrument.
Yes, but they have reason to doubt that.
What reason do they have? They've told me that my brother lacks mental capacity potentially.
Right.
You've read that. It's not what they've presented to you is not definitive, is it? It's not a fact.
But Minister, processes around validating.
I'm not I'm disputing. My dispute is with you, because you have accepted their refusal of a lawful and legal instrument. Okay, Mr. Steele, what do you want me to do? What would you like me to do?
Right, I would say that this is an issue that you need to take advice on, because the crux of the matter here is that they are not accepting your legal power, your power of attorney, are they? They're not accepting it.
But they've got their own nefarious agenda. You know, if it's been invalidated, that's one thing, but it's not been invalidated, has it?
We can't tell an organisation. We can't.
Okay, all right. You can't tell them this, but let's just back you up a little. Why don't you tell them that if after the 2-month extension you are telling him that it's not valid, why did you not tell him after the 30 days or within the 30 days?
Okay, which is fine, but that's their process.
It's not their process. It's the law. If they have a different process compared to the law, you know, all processes have to be compatible with the law. The law states that they have 30 days to comply.
Okay, so we could reach them on that they took longer than they should have done to make a decision on the subject.
No. That's not what I'm saying. Is that they have accepted the lasting power of attorney because they sought a 2-month extension. So you can say to them, well, wait a minute. On the one hand, you're telling us that you don't accept the lasting power of attorney after you've had 3 months on some matter. So after the 3 months, you say we don't accept it. But why? You must have accepted it in order to get the 2-month extension.
But that's something that you would have to ask them.
No. It's not something I have to ask them. It's something that you have to ask them, because you're the regulator. If they're telling you porky pies, is that my job to get them to tell you the truth? But sorry, Mr. I'm getting slightly aggrieved at this, because you understand that they cannot, either you accept something or you don't. It's not a case of, well, we're going to do one thing or the other. If they have applied for the exemption of if they have applied for the extension, then ipso facto, by definition, they have accepted the lasting power of attorney, have they not?
Well, I would say that we could question them why they didn't doubt the application in initial circumstances.
That's right, yes, because
we made it. Yes, we could do that, but at the end of the day, whether it was in day 1 or a month later, yes, they would have been. I can see where they've asked for the extension. I understand that. So at that stage, you would probably think, yes, they're just wanting more time. But I don't know what's gone on behind the scenes there that has made them come with this decision.
And why would you want to know what's behind the scenes? You're the regulator. You have the law in front of you. You know the fact that they have 30 days to comply.
Yes, I understand.
That's right. It's clear cut. They've got 30 days to comply. They within that 30-day period, did they inform me or say that we don't recognize this lasting power of attorney? No, they did not.
But it's the fact that they're saying it now.
Irrespective of whether they're saying it after the event, what else do you want them to say? Because they failed. If they fail to do something, they're just grasping at straws now. All right. And what concerns me is not what they're doing, is what you're doing. Because you're now, this is your position. This is what should be your position. Your position should be, okay, well, we've got this legislation in front of us. Does it fit in with this legislation? And you're saying, well, what they're doing is saying something else, or we can't even regulate. That's not acceptable, because this is a subject access request that I made, that was I hold today is still valid. They accepted it because within the first 2 weeks or a month, within the month period that they had, they did not raise it as an objection. Why did they not raise it as an objection then? What they've done is they've accepted the lasting power of attorney and looked to find some exemption or excuse, or basically fobbed for more time. So after the fobbing for more time, they said that, because it's complex, because remember, it's not just, you don't automatically get the 2-month extension. It has to be because the situation is complex. They've stated to me that, yes, it is complex and we need more time. Once they've asked for the extension, they can no longer make the argument of the validity of the lasting power of attorney because they've already accepted it. Now, moving forward, I then permitted them to have time. I then, as you can see from the email chronology, told them, look, your time is up. and given them notice, place them on notice that your 2-month extension period expires in 5 days or 6 days or a week's time. So they've been on notice. They could have told me at that stage that, oh, we are not accepting the lasting power of attorney. They waited until the very last day. And you can see when they've told me. They've told me on the very last day, oh, by the way, no, we're not going to accept the lasting power of attorney now. Because ultimately what they're doing is they're making a perversion of the legislation which you're administering. Because ultimately you can take the Data Protection Act 2018, you can rip it up, flush it down the toilet because it has no value. Because that's ultimately what they've done. It's just a red herring. Because here they are, they're obligated to comply with the law. They've not done so. You as the regulator are taking a hands-off approach and saying, well, we're just going to listen to what they say. That's a bit like me, Mr. Jones, raping somebody and then once being questioned by the police and saying, no, you're just lying. And you're saying, we're going to accept what you're saying. Is it my word against their word? Or is it the fact that you have in front of you a legal instrument of a lasting power of attorney? I've explained to you that under the Capacity Act, the very first principle is to assume somebody has capacity. So their defense goes against the very law because they're assuming my brother lacks capacity. And he doesn't. So I can't prove something, evidence something that I'm not supposed to evidence in law.
But you're disputing a decision made by a council that isn't a data protection issue. It's an issue of whether or not they're accepting the lasting power of attorney. They are clearly, for whatever reason, and I understand what you're saying is that it is deemed by the email trail that they did accept it at the beginning, but I don't know what investigations or whatever they were doing in that period where they asked for an extension.
Well, why don't they be open and transparent then? I mean, you're not supposed to do things covertly.
That's what you would have to ask them about.
No, but what are you doing as the regulator? Because remember, I'm not having a conversation with the council. I have many conversations with the council. I know what they're doing. I know why they can't disclose my brother's data. Because ultimately, they then incriminate themselves. Because you see, this is one of the problems. Because the Data Protection Act make it so that you have to by law disclose information, and therefore they themselves have a conflicted interest, because on the one hand they're supposed to be open and transparent. On the other hand, if they disclose this data to me, my brother's data to me, all right, which I've got the lawful authority to do, they in essence incriminate themselves. So they're going to be clutching at straws. So I understand their motivation. All right, because I understand that as soon as they comply with the Data Protection Act, that they have in essence incriminated themselves. Now you're going to tell me, like anybody else, is that, oh, the local authority can't incriminate themselves because they can't be criminals. Well, that's your personal opinion. It doesn't make a difference to me, Mr. Steele. The reality is that this is the justification why they can't disclose the data to me.
But that's where you should be making a legal challenge.
Okay, I will make that legal challenge, but before I make any legal challenge, as you know, I am going to the regulator as yourself to ensure, just like we've had this conversation today, and the reason that we're having this conversation is in relation to the conduct and behaviour of your colleague Alison Fletcher, yes? Yes, and you see, I've sat here and I've explained to you all the mistakes that she has made, and you have courteously agreed that yes, those were mistakes, and now we're going to be looking to review them. You can only do that after I have listed all those complaints. Now, similarly, at the local authority, I'm coming to yourself as a third party, and your focus should not be on what they're saying. Your focus should be directly at the legislation. I didn't make anything else that they're disputing. I did not ask for anything else. I made a subject access request on behalf of my brother with a lawful instrument in place. If they are refusing to accept the lawful instrument in place, that is, they are acting against the law. By you then accepting that, what their argument, you are then becoming their co-conspirator and collaborator, because your focus should be, I don't care about Mr. Hussain, I don't care about the local authority. What I care about is the law and the legislation that I'm paid to regulate. And the legislation states that anybody can make a subject access request. My brother cannot make a subject access request on his own. He requires my assistance, and he has authorized me to act on his behalf through the lasting power of attorney. I've then proceeded quite rightly, to have that registered with the Office of the Public Guardian. The Office of the Public Guardian to this day have not negated that. So that's a lawful instrument in place. All right. And that's what you should be. So the first question you should be asking is the subject access request made by the requester valid? And the reality is that it has to be valid, because my argument is that if it was not valid, it should have been made prior to the 30 days. They should have turned around straight away and been open and transparent, as you would expect any organization, particularly your local authority, to say, nope, this is not valid. They didn't do that.
If an organization tells us that they do not see it as a valid...
Mr. Steele, what did I just state? They have a 30-day window. If they stated it's not valid, it should have been done at the appropriate time. They did not do that. They then accepted its validity because they then asked for a 2-month extension. That extension that they've utilized is something in law under the Data Protection Act that cannot be executed if it's not a valid request. It has to be by definition a valid request for them to utilize that 2-month extension. You can say to them, well, if it was invalid, why did you not be open and transparent and tell Mr. Hussain it's invalid? Why did you accept it and got a 2-month extension? Once they've received the 2-month extension, they could have told me at any stage that we have questions regarding the validity of this lasting power of attorney. They did not do this. So you can ask as a third party is that there's a reasonable course of conduct and behavior. One is that you be open and transparent. If you've already accepted that you're going to get an extension, and then on the why did you wait until the final day? All right, after I'd sent you several reminders. These are questions you can ask them. Because if, as I've stated, if they've done something wrong, they're not going to be putting their hands up and saying, yes, we've done something wrong. Are they?
But if that organisation had to make some inquiries as to why that application might be not a valid one, well then surely they could not maybe be upfront with that at the very beginning.
Okay, that's fair enough. No, of course they can. They can say, well, we need to investigate this.
But Mr. Hussain, what you're saying here is that you're questioning their internal process.
No, I'm not questioning them. I'm not talking to the council right now, am I? I'm questioning you.
I know what you're saying. What you're saying is that they have used the
yes, sorry,
as if it was a valid request, and that the LPA was accepted. I understand you are saying that. Retrospectively, if we went back to them now to say, why did you do that? They could come up with a various number of reasons. But if they were saying it's because they were investigating, at the very... Well, I'm not sure what we could actually breach them on, to be honest.
Well, wait on a minute. They're just making a perversion of the law, and you're saying there's nothing we can pull them up on. Just hold on one second. I mean, like I said, I'm not focusing on them. I'm focusing upon yourself, and you're saying there's nothing we can do about it. The reality is that I'm not sure if you're fully aware of this, Mr. Steele, but I have lodged numerous complaints about the local authority, and many of the time they've all been upheld. All right. So, as the ICO, they've lodged complaints about me as well. All right. They've asked me to be criminally investigated by the ICO. All right. So me and the local authority have a long-standing conflict. All right. So it's me, private citizen, versus the local authority. They've looked to take action against me through yourself. All right. And you can see this on your records that I have been criminally investigated by the ICO, and nothing was upheld because they had lodged a complaint. So what concerns me, and I'm just going to take a slight digression here. I walked in as a member of the public into the local authority's city hall and asked to run as a councillor. They handed me the district's resident's name and address. I lodged this as a complaint with them because you did not ask me who I am. You didn't not even take any identity from me. I just walked off the street, claimed to be running for a councillor, and you just basically handed me over 11,000 names and addresses of my local residents in the district without any further question. I took issue with this and I lodged this as a complaint to them, saying that their policies and procedures need to be rectified, because here we are under the Data Protection Act. The data protection, anything that can personally identify somebody should be protected. And here I am, just Joe Bloggs, walking off the street and asking the council, I want to become a councillor, and then without me identifying who I am or any identity or anything or making me aware of anything, they've just handed me over 11,000 people's names and addresses. I lodged that as a complaint with them. What was their response? They lodged a complaint with yourself stating that I've done something wrong, that I've tried to get me on criminal charges. And they failed on this because after after yourselves, the ICO investigated this, they said that we don't have a grounds to take any further action against me. So there's a conflicted relationship between me and the local authority, right? That's very clear and evident. I've made numerous other subject access requests in my own right that have been denied to me. I've spoken to one of your colleagues called Dan Stojic. He's upheld my complaints in my own right, because this is a complaint that I'm holding in my brother's rights. I've made complaints in my own rights that have been upheld, that they failed on. Now, it seems that in this particular case that you're looking into, that you're willing to give them a very long leash and accept what they're saying and saying there's nothing we can do about it, when the reality is that they're making a perversion of the very law that you're regulating. Because as I've expressed to yourself, they're not complying to any law. Because all the time they're saying we don't accept something. If Mr. Steele, if it was not a valid legal instrument, then they're within their grounds to do that. Number one. Number two is that you've mentioned to me that maybe they're investigating. Okay, that's fair enough. They've had an opportunity to investigate from November onwards. It can't be an indefinite thing. Now, the situation we're now being left in today is that you're saying that we're upholding what they're saying. That means that I can't do anything further indefinitely. My brother is not going to get his information indefinitely, is he? However, if you uphold that they are not complying with the legislation, that gives me an avenue of redress, because I can say, look, I've gone to a third party, I've gone to a regulator who accepts that they failed on this. Because if I take any further legal action stating that they're doing something wrong, they're going to say, well, look, hey, we went to the regulator and the regulator concurs with us. So, you're leaving us in a very difficult situation, because what they're saying, if the legislation permitted them to make an exemption, apply the exemption, tell me what the exemption is. You told me prior to this conversation that they have applied an exemption and we accept the exemption. In this call now, you're telling me that there is no exemption.
No, what I'm saying is that they didn't. They quoted an exemption that was wrong. Okay, which we have conceded that.
Okay.
They didn't totally rely on the exemption. Their reason for not accepting it is that they view it as not a valid.
Okay, they can view it, but
and don't need, and we cannot. If an organisation says they are not accepting it, they have given us reasons in their reply. The subject access request that you've made, if you receive a copy of their reasoning, you will see the reasons.
Okay, all right, okay, that's fair enough. But irrespective I'm sorry if I'm repeating myself. What relevance is that? Their reasons is irrelevant to the law.
Well, no, it's not.
All right, well, tell me why it's not relevant. Why and it has any relevance to the law? Tell me, please.
Because that organisation believe that is not a valid, and they have a duty of care to protect.
Under what section of legislation?
Well, this will be under social care legislation.
No, Mr. Steele. It really perturbs me now that you're acting and what you're saying to me, because I'll tell you why. Because I wrote to you. I've recently written to you, haven't I? Let me just ring this up. There is a section. It's section 173 of the Data Protection Act. Do you know what that section states?
About altering information or deleting information.
No, I'm sorry. I'm misquoting here. Just 1 second, please. Okay.
I mean, don't forget, Mr. Saying this is a call very specifically about the LPA here.
Yes, Mr. What I'm trying to state is that they can apply an exemption, and their defense can be if it is a defense if for a person charged with the offense under subsection 3 to prove that section B, the person acted in the reasonable belief that the person making the request was not entitled to receive the information in response to the request. Now this is this is in the legislation under section 173. So if they've quoted to you that we're not going to provide this information and we're relying on this defense, then that's something within the law. So have they quoted you 173?
No, they haven't.
Okay, if you look at section 173, it's of the Data Protection Act. It provides they cannot, they are within the position, and we're still now in the Data Protection Act. We're not going into anything else that you're unfamiliar with. 173 states that you don't have to provide the information, and if that charges are brought against them, their defense is listed in section 9. In section in 173 paragraph 5. No, subsection 5. So 173 subsection 5. If they've quoted you that, then that's fair enough. Then you can say to me, Mr. Hussain, look, they're relying on section 173. And therefore, we're accepting that, and that's their defense. But they've not mentioned this law to you, have they? They've not mentioned this section to you.
This decision is based purely on, they are saying that the LPA is only valid if Taliban...
Mr. Steele, I'm quoting to you legislation and you're giving me circumstantial, what they said, he said, I said, she said. They should have come back to you and said, as the regulator, that we're applying 173. Yes, we're not going to give the information because of 173.
Right, we know they've quoted the wrong legislation.
Okay, so they're clearly incompetent then, aren't they? Because they've had 3 months to quote, because I deal with the local authority, and Mr. See, I live in Bradford. I know these people are incompetent. And I know they can't do the job properly. So I know them. So if they've quoted you incorrect legislation, are you not going to reprimand them on this? Basically, they've quoted, sorry, Mr. Steele, they've quoted you incorrect an exemption. Your colleague has then quoted me incorrect exemption, which you've accepted. So it's just basically, I'm surrounded by people that just can't seem to know what the law is. Because why would a local authority who have a dedicated legal team who should know the law quoting you incorrect exemptions? And then why are you then quoting me incorrect exemptions?
No, I'm not quoting incorrect exemptions.
No, your colleague did, didn't she? Your colleague did.
But what I'm saying is that there isn't a requirement for an exemption for this reason.
No. So you basically can tell me. So let's get this right then. So you working in the ICO are telling me basically another technique of getting out of complying with the legislation. So I, as a private organization, all right, as a private organization who are registered with yourself as a data protection controller, have now identified a technique where I can say that if somebody presents me with a legal instrument like an authority letter, just an authority letter, all right, never mind a legal instrument, I don't have to accept it because I'm saying I don't believe it, and therefore I don't need to comply with the Data Protection Act. Is that what you're telling me today?
No, I'm not saying.
Yeah, that's exactly what you're saying to me, Mr. Steele, because you're telling me today that, if an organization does not believe the authority letter, they then no longer covered under the Data Protection Act. They can just do what they like. Just like in our conversation today, Mr. Steele, that we have, one of the complaints I have is that you as the ICO have determined that instead of, you would take a month to ask for more information and reset the clock.
Right, Mr. Hussain, I think, as I said all along, the bottom line here is they have not released this information.
And they're entitled to not release this information under Section 173.
Right, well, if that's what they need to say...
They haven't said that, I'm saying that.
Okay.
And you should recognize that they don't have to give me the information under Section 173.
Right.
Okay, under Section 173, they don't have to give me the information. And the defense that they have is that we don't reasonably believe that it's a valid request. They've not even quoted you that. Why am I, as a layperson, quoting you the legislation that you're supposed to be an expert at, which they're supposed to know about, if they're not provided you with the data, that the legislation framework provides that. We're not going to go into some other legislation like social care or whatever. This legislation, a valid request was made. We're now dealing with data.
Yeah.
The legislation is comprehensive enough to look at the exemptions. It's comprehensive enough to identify when they don't need to apply. Section 173 states that. They've not quoted that to you. They've quoted to you some gobbledygook about we don't accept this and blah 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 whatever.
Yeah.
All right.
I've only looked at the case in detail this morning, basically. Yeah.
Yes.
For this phone call. Okay. It is. I do have in mind to go back to the council to clarify the reasons, but the bottom line is that they're not accepting it as a valid application for LTA, and therefore they are quite entitled not to give information out.
Okay, but I've just quoted to you what their defense is. I've quoted you section that they should be coming back to you and saying we're going to do utilizing section 173 because they've got the solicitors involved and they don't know this. So I'm telling you to tell them to say this, and that's their defense.
Where's this going to get you with your application?
But the reality is this, that I don't care about them. I'm concerned about your conduct and behavior as the regulator. All right. Because obviously, if I'm taking legal action, I'm not going to just taking action them. I can take action against you because as the regulator, can you tell me, are you an advisory body or a regulatory body?
We're a regulator.
All right. What's the difference between an advisory body and a regulatory body?
I couldn't tell you. We're a regulator.
What's the difference between an advisory body and a regulatory body?
Mr. Hussain, this isn't a chance to test my.
No, I'm not testing you, and I don't mean to put you on the ropes here. And you know, if you're saying, look, I'm unclear, that's fair enough. But my understanding is that, and I just want to be quite clear upon this, and I've had this issue with many other organizations as well that are regulators. A regulator has the power to take legal action. Yes. An advisory body does not.
Yes, we do have the right to.
Exactly. But what you're ultimately doing is that you are a regulator, but you're acting as an advisory body. And in essence, what you're saying is that we're not going to do anything because we don't believe that, we don't have to do anything. You have the power, but you don't have to execute the power. And in order for you not to execute the power, all you have to do is give advice to people. Now, I know for a fact that the local authority, my local authority, as I'm a citizen, have a complete disregard to the Data Protection Act. Complete disregard. They don't care. They don't have the resources. They don't. It's just an inconvenience to them. I've come to yourselves as the regulator, and because of a resource deficit on your part, and because it's not in the public, it's not. It looks problematic where you're taking action against a public authority, that you're not willing to do anything. However, it's a private organization, you're going to come down on them hard. And that's what concerns me. But in this particular context, you were informing me about, we've made a decision. I need to have the decision in writing. Now, your colleague, Miss Fletcher, wrote to me and said that we're upholding their exemption. So I can only go on what's written. All right. So she said we're upholding the exemption. Now, through this conversation, we've realized that there is no exemption. So at the end of this conversation, because I'm just conscious of the fact that we've nearly been on this call for an hour, and you've been very courteous in order to listen to me, and I don't want to be taking up more of your time. What I would like to see, other than the other points that we've raised as grievances, is I would like you to come back to me in writing and state to me that either you uphold my complaint or you don't uphold my complaint. If you don't uphold my complaint to yourself, then I would like you to detail to me with quotation of the legislation of why you don't uphold my complaint. I need something in writing, because what I've so far have in writing is that from Mr. Fletcher stating that they're upholding the exemption. In our conversation today, we realized that there is no exemption, all right? And so therefore, I need you to put something in writing to me, and maybe we can review the situation after you've written to us.
Mr. Hussain, I will tell you that I'm actually on leave next week, so I will start that on return on the 24th.
Okay, not a problem. I mean, I accept this. And can I just ask, what position you hold in the ICO?
I'm a manager.
Okay, and can I ask, who are you managed by?
I'm managed by a lady called Helen Raftery.
Helen Raftery, and what is her position?
She's group manager.
Okay. And who's she managed by?
Oh, we could go up the chain.
Yes, that's what we're going to do.
Right, okay, she's managed by Lisa Stellan.
And what position does Lisa Sellers hold?
She's head of department.
And who's she managed by?
Right, she is managed by, just bear with me a second.
Yeah, sure.
My mind's gone blank after this hour.
It's not important. Can I just ask, upon your, who, I'm just trying to find out who is under the chief executive, so how many levels is it?
Oh, crikey.
Because obviously, if it's like you said, a group manager, department manager, is the department manager accountable to the chief executive, or is it a director in between?
Director.
Could I ask the director?
Yes, Suzanne Gordon.
So Suzanne Gordon is the director directly under the chief executive.
Yes.
All right, and then obviously yourselves are followed down the chain. Yes.
Yes.
Okay, that's okay. Is then, I mean, okay, it's not a priority for me right now, so I don't mind if you look into this once you come back after holidays. What date did you say? 24th?
I'm back in on the 24th.
Okay, and should we say about a week later?
Yes, to be realistic, yes.
Okay, so towards the end of September, you'll be able to have much more of a clearer,
a more detailed decision for you.
After I would advise you to discuss that with your senior managers as well, because at this stage I need either an exemption or I need a legislation quoted to me in order for me to take the matter forward. Is that okay?
Yeah, that's fine, Mr. Stein, yeah.
I once again appreciate your patience. I know this has been a lengthy conversation, and I know I can come across as quite confrontational at times, but obviously, as you can appreciate from my own side, I feel very aggrieved that my hands are being tied and we're being given a runaround, and there have been mistakes made by various people, including your colleagues, and which you've owned up to and accepted. So I just wanted to personally say that obviously there's no animosity between us, and I appreciate your patience.
Okay, absolutely. Yeah. The same goes to you. Thank you, Mr. Stein.
Okay, have a nice day, Mr. Steele. Goodbye.